afternoon, everyone, and welcome to today's Employment Law Lunch and Learn presented by Kelleher and Holland. Every business has something that makes it special, a big idea, a strong brand, or a unique process. But standing out is only half the battle. Protecting what sets you apart is just as important. And today we'll break down the essentials of intellectual property, or what we are calling IP, and how to protect it. So you'll know how to keep your competitive edge safe in the workplace. If you are a regular attendee of our webinars, you will see a couple of new faces today. Robin Kelleher and David Munt are two of our corporate and IP attorneys who help companies safeguard what makes them unique. And today they'll share practical insights to help you protect the value that you've worked hard to build. And also with us is Madeline Kelleher, a regular participant in this webinar series. Madeline brings her insight on employment law, and today she'll highlight how workplace policies and practices play a key role in protecting your business's most valuable assets. So with that, Madeline, let's get started. What is intellectual property?
So intellectual property, or IP, refers to creations of the mind, innovations, brands, and works that provide a competitive advantage to businesses. Businesses often overlook intellectual property until there's a problem, but protecting these assets from the outset is absolutely critical. Broadly, intellectual property falls into four categories: trade secrets, copyrights, trademarks, and patents. Each offers different protections and requires different strategies, and we will go through each of these four categories today.
So why is IP so important?
So intellectual property is often one of the most valuable assets a business owns that sets them apart and drives up value. Think of companies like Apple, Disney, or Coca-Cola. Their physical products matter, but what really drives their value are the patents, trademarks, copyrights, and trade secrets they own. Even for smaller companies, intellectual property can be the difference between leading a market and losing ground to competitors. In a few words, intellectual property builds brand recognition and trust, encourages innovation, encourages investment, creates revenue opportunities such as licensing and franchising, increases business valuations, manages risks and compliance, and of course, protects competitive advantage.
So as Madeline mentioned earlier, we're going to dive into the different types of IP that there are. So Robin, what is considered a trade secret?
Hello, everyone. Interestingly, some of the most valuable IP is never even registered at all, and those are trade secrets. Generally speaking, a trade secret is information that has value because it's kept confidential. It could be a formula, a manufacturing method, a customer list, or a business strategy. As an example, think of the Coca-Cola formula. That's an example of a trade secret. It's never been patented because patents expire. Instead, it's kept in a locked vault, known only to a handful of employees. Protecting trade secrets means controlling access, using non-disclosure agreements, and having internal policies to prevent leaks. Once information becomes public, it's no longer a trade secret, so prevention and protection is everything.
So let's talk a little bit about copyrights and what may qualify for one. How long does the copyright protection last?
Sure. Copyright protects original works of authorship that includes books, software code, photographs, marketing content, videos, and music. There are three key requirements to get a copyright registered. That is originality. The work must be independently created and show at least a small degree of creativity. It doesn't have to be groundbreaking. Authorship. It must be the product of human creativity, not AI. So ideas, procedures, methods, or facts themselves are not protectable. Only the expression of them. Fixation. The work must be captured in some form, written down, recorded, digitally, is possible as well, not just existing in someone's mind. This is otherwise known as being fixed in a tangible medium. Some more examples of things that qualify include literary works, musical works, artistic works, dramatic works, such as like notated or recorded plays or choreography, audiovisual works like TV shows and movies, and architectural works like designs for a house, for example. Some things that would not qualify for copyright protection are ideas, procedures, methods, systems, or processes. Titles, names, short phrases, or slogans are usually protected by trademark law, which we will get into next. Facts, common information, or works entirely made up of public domain content are also not protected by copyright. The duration of a copyright protection for most works is the lifetime of the author plus 70 years. Works made for hire, or otherwise known as employee-created work, is 95 years from the date of publication or 120 years from creation, whichever is shorter. So one important thing with copyrights that's worth noting is the difference between actually registering a copyright and the automatic copyright protection that exists once a work is created in a tangible form. In the US, copyright protection arises automatically the moment the work is created. You don't have to file anything, pay any fees, or put the C in a circle symbol for protection to exist. This automatic protection gives you the exclusive right to copy, distribute, perform, display, and make derivative works of this particular creation. However, while you have automatic rights, can be hard to enforce them in court without formal registration. Registering your copyright with the U.S. Copyright Office gives you critical advantages, like first, proving ownership and the date of creation, the ability to sue, since you must register before you can bring a copyright infringement lawsuit. Third, the ability to obtain statutory damages and attorney fees from the infringing party. And lastly, it adds credibility and makes it easier to transfer rights to, let's say, a buyer of your business. So that is why the registration process for copyrights can be very important. And I also want to mention too, you frequently may see on websites the copyright indication, which is very common, and we would advise any client to do for on their website. But yet that's a good example of where, because it's a always changing work, you would not actually file for copyright protection of the website. But it's a good example of where you'd want to go ahead and put that copyright indication on your website.
All right, let's get into trademarks. I think this will really resonate with our audience today. So let's talk about what they are, what can and cannot be trademarked, how they are different from copyrights. What is the trademark registration process like?
Sure. So the legal definition of a trademark is it refers to any word, phrase, symbol, design, or combination thereof that identifies and distinguishes goods or services from one entity of those of another. So it's basically a person or an entity's branding. This encompasses both trademarks applicable to goods and service marks applicable to services. Federal status is achieved through registration with the United States Patent and Trademark Office, which grants nationwide protection and presumptive ownership rights under the Lanham Act. Unlike common law trademarks, meaning marks being used in commerce that are not officially registered with the USPTO, federal registration provides constructive notice of ownership across the United States and facilitates broader enforcement against infringement. So let's talk a little bit about the use and need for federal trademarks for a business. They serve primarily to identify the source of goods or services, thereby building brand recognition and consumer trust. Just to name a few very well-recognized trademarks, when you see them, you know exactly what you are getting or what they are selling, those being McDonald's, Nike, Coca-Cola, Home Depot. In practice, registered trademarks allow for the use of the R in a circle symbol, which signals federal protection, and it deters potential infringers. If you do not have an official registered trademark, you cannot use the R in a circle. Trademarks are category specific, meaning that protection is limited to classes of goods or services registered and does not extend to unrelated fields. Therefore, there could be identical trademarks in name that can coexist because the goods are unrelated and confusion in the marketplace is unlikely. If the mark is not federally registered, a common law owner is allowed to use a TM or an SM next to the mark or logo. So let's talk a little bit about why federal protection is important. You have nationwide priority from the date of filing. So basically the date the application is filed, you would have priority over any subsequent user that may have a similar mark or logo. Access to federal courts. So like copyright registration, for infringement actions, you must have an actual federal registration in order to sue in federal court. It also has enhanced remedies such as treble damages and attorney fees in the case of willful infringement. It is particularly essential for businesses expanding interstate or internationally, as it forms a basis for foreign registrations under treaties like the Madrid Protocol. And in our increasingly digital economy, federal trademarks are indispensable for safeguarding intellectual property against counterfeiting, cyber squatting, and global competition, ultimately preserving economic value and mitigating litigation risks. So let's move into the registration process. If all goes well, it takes approximately a year to get a mark registered. However, the priority date, as I mentioned before, is the date that the application is filed. After the review process, which takes about 7 to 9 months, if the examiner approves it, the mark is published for opposition in an official publication open to the public to review. There's a 30-day publication period. If no one opposes registration of the mark, then it will officially register about 6 weeks after that. So that gets us to about a year. Registration is good for 2 5-year terms and then goes to 10-year terms. The registration needs to be renewed through the USPTO, and the owner must show continued use every time that it's renewed. So in order to keep your federal registration, you must demonstrate that you have used it continually over that registration period. Let's talk a little more about what is trademarkable. After describing what this means, I'm going to use a few token phrases that may not make a lot of sense, but I do have some examples that hopefully they will make more sense. In addition to selecting a mark that is not likely to be confused with any pre-existing marks, it is in your best interest to select a mark that is considered strong in a legal or trademark sense, meaning a mark that will most easily allow you to prevent third-party use of your mark. Some marks are easier to protect than others, and these are considered strong marks. On the other hand, if a mark is weak, it is most likely descriptive and others are already using it to describe their goods or services, making it difficult and costly to try to police and protect it. Weak marks should be avoided. They simply cannot get the same legal protection of a stronger and more distinctive mark. Generally, marks fall into one of 4 categories: fanciful or arbitrary, suggestive, descriptive, or generic. The category your mark falls into will significantly impact both its registrability and your ability to enforce your rights in the mark. As trademark attorneys, we can guide you through this branding or naming process. The strongest and most easily protectable types of marks are fanciful marks and arbitrary marks. So what does this mean? They are inherently descriptive. Fanciful marks are invented words with no dictionary meaning and no other known meaning. Arbitrary marks are actual words with a known meaning that have no association or relationship with the goods. Fanciful and arbitrary marks are registrable and indeed are more likely to get registered than descriptive marks. Moreover, because the marks are creative and unusual, it is less likely that somebody else is already using those names. So an example of a fanciful mark is the word Belmico for insurance services, Belmico. So that's an example of a made-up word. There's no dictionary meaning, and it's being used in association with insurance services. So that's a good example, if it's not already being used by somebody else, which is unlikely since it's a made-up word, of something that could most easily be registered with the trademark office. An example of an arbitrary trademark would be banana for the sale of tires. So you might think, that's an existing word with a dictionary meaning, but I'm selling tires. I'm using it in conjunction with the sale of tires. So that's an example of an arbitrary trademark use. A second option is suggestive marks. So they do not, they suggest, but they do not describe the qualities or connection to the goods or services. Suggestive marks are registrable and also considered strong marks. If you do not choose a fanciful or arbitrary mark, suggestive mark is your next best option. An example of that is Quick and Neat for the sale of pie crust, or Glance a Day for the sale of calendars. So those marks suggest what you might be selling, or services or goods, but yet they don't describe specifically what you are selling. So an example of, just to wrap up what is trademarkable, so words or phrases that are not so great to choose when you're trying to get trademark protection are descriptive marks or generic marks. So an example of a descriptive mark would be, for example, a picture of a television set for a television repair service company. So that might be a little outdated since TVs tend to be disposable now, but that would be a historic example of something that would be descriptive of your services. Such marks are generally considered weaker and therefore more difficult to protect than fanciful and arbitrary marks. If the USPTO determines that a mark is merely descriptive, then it is not registrable or protectable on the principal registry, unless it acquires distinctiveness. Lastly, an example of a generic mark would be the word creamy for yogurt or the word world's best bagel for bagels. So obviously those are not as protectable because they simply are generic terms used to describe what the goods are.
All right. Thank you, Robin. David, let's get you involved in our conversation here. Let's talk about patents. Can
Okay.
you
Hello, everyone.
describe what a patent is, what can and can't be patented, and a little bit about the application process?
Sure. Well, when people hear the word patent, they usually think of the right to make or sell something, but that's not really what a patent is. A patent is an exclusionary right that's given to the holder from the government in exchange for the public disclosure of the invention's details. It gives the owner the exclusive right to make, use, and sell what has been claimed as the invention. There's three types of patents. Utility patent, that covers how something works. Design patent covers how something looks. And then there's the plant patent, which covers asexually reproduced plant species. So that's kind of the basics of what a patent is. What can and can't be patented? Well, you can patent articles of manufacture. For example, a new design of an adjustable wrench. You can patent a machine, for example, a new equipment for manufacturing a composite baseball bat. You can patent a method, for example, a new process of purifying water. You can patent a system. For example, everybody has a smartphone, so a new application software for your smartphone you get a patent on. You can patent a composition, for example, a new pharmaceutical compound. What you can't patent are abstract ideas without any practical application. For example, a mathematical formula like E equals MC squared. You cannot patent laws of nature, for example, gravity. You cannot patent naturally occurring substances, for example, oil. So what's the patent application process? Well, a patent must be new, it must be novel, and it must be non-obvious in light of what was previously done before. And so we call what was previously done before prior art. So the first step in the process is to do a prior art search to make sure that this new idea is new, novel, and non-obvious. So the client does a search, the lawyer does a search, and if the searches come back clean, the lawyer and the client work on a patent application that will eventually be filed with the United States Patent and Trademark Office. That application consists of a set of drawings, a detailed description of those drawings, and then most importantly, a set of claims that basically use legalese to define the scope of what the invention is. Once the client and the lawyer are good with this application, it's filed with the patent office, and it gets assigned to an examining attorney there. And the typical time frame now is about 18 or 20 months before it's picked up to even looked at for the first time. That examining attorney will look at it for statutory requirements of patentability, but most importantly, they're going to look at the claim set and how you're trying to define your invention. They're going to do their own prior art search. They're then going to send you an office action back that then says whether or not they believe that the claims of the patent as you submitted them are allowable in light of the prior art search that they conducted. They'll send you that action back. You then sit with the client and figure out whether or not there's an argument as to why the examiner's positions are incorrect, and or how you may be able to limit the scope of your claim set to get around whatever prior art the examiner may have found. So that back and forth process happens until hopefully at the end of the day, there's an allowed set of claims that are eventually issued. And at that time, when the patent issues, that gives the patent owner the right to exclude others from making, using, and selling what was claimed in the invention, not necessarily what was shown in the drawings, not necessarily what was talked about within the specification of the application, but what has been claimed as the invention. So when that issues, that right starts, and in order for that right to maintain its full term, that term is 20 years from the filing date of the application. In order to maintain that full term, you have to pay 3 maintenance fees. They're basically taxes. Those fees are due at the 3.5, the 7.5, and the 11.5 year after issuance of the patent. As long as they're paid, the patent will make its full term.
All right. Madeline, can you share some other ways you can protect your intellectual property?
Yeah, absolutely. So protecting your intellectual property depends on the type of intellectual property you have. Each form has different methods and strategies for ensuring your rights and are enforceable and your creations or innovations aren't stolen. So besides registering your intellectual property with the appropriate authority, as David and Robin had already discussed, there are a few other practical and strategic ways to protect your intellectual property. So, and more preventative ways as well. One would be licensing agreements that allow others to use your intellectual property under controlled terms and for a fee. Internal company policies. This is the good one to reinforce non-disclosure of confidential information and assignment of intellectual property and contracts, which I'll get to in a minute. Physical and digital security, such as access controls, encryption, cybersecurity, document control, and the labeling of confidential materials internally is also very important. Another is consistent branding and marketing, and the use of your trademark or copyright symbols and everything that is registered or naturally owned. And if you don't, you could potentially lose your rights to your copyright or trademark. Regular training of employees on the policies and consequences of misuse is also a good preventative way. And of course, most importantly, contracts and legal agreements with employees, vendors, independent contractors, anybody you work with that has access to your intellectual property, including clauses like non-disclosure of confidential information, which in its definition would include intellectual property, to protect sensitive information when sharing it, return of company property and information and materials upon exiting the company or terminating the relationship with your independent contractor. I found this one to be one that's pretty important to include your contracts, because without it, you can get back a blank computer or something where all your stuff's gone from your employee or independent contractor. And then a non-competition agreement could also be helpful to limit key employees from working with competitors and using your intellectual property. Most importantly, assignment of intellectual property to the company, which intellectual property is not already considered works made for hire, which I'll explain in a minute. To ensure that your inventions relating to the company's actual or anticipated business, research, development, that's created by your employees, whether on their own time, with others, or on company time using company resources, making sure that remains the property of the company. It's important to note that protecting intellectual property isn't just about registration or taking other preventative measures. It's about vigilance. That's why it's also important to monitor the marketplace. If you see infringement, you can begin with a cease and desist letter. Sometimes that resolves the issue, but other times litigation is necessary. Knowing when to escalate is a strategic decision that weighs cost, risk, and business impact. And of course, registration and taking other preventative measures will help you during the litigation process tremendously. So going back to works made for hire, there are two laws that I also want to mention that protect intellectual property in a more legal way than contractual or registration or anything like that. One of them is the works made for hire term. What this means is that if a creator is an employee and creates a work within the scope of their employment, or if the creator is an independent contractor and that work falls into a specific category under a written agreement, the hiring entity is considered the author and initial copyright owner of that work rather than the actual creator. Another is if a trade secret is stolen, you can sue under state law or the Federal Defend Trade Secrets Act. But the key here is still prevention. Once information becomes public, you cannot put that genie back in the bottle.
I'd like to open this one up to any of you. How can KH help people looking to safeguard their IP?
I would say, first of all, we can definitely help with the registration process. And first, prior to that, advise clients on, selecting for trademarks, selecting, certain branding options, and as well as advise as to what may not be a good route to go.
Yeah, I would add that we not only can we file and prosecute and maintain the patents, but we can do patent opinion work, like a right to use opinion or perhaps infringement opinion. And should it be necessary, we can certainly do patent litigation.
And then we can also help establish your internal policies, training procedures, and contracts to protect your intellectual property in a more preventative manner.
Got a couple minutes left for a little bit more information. David, what are some IP best practices that businesses can do?
All right. Well, very, very quickly, I have a few here. You can be very proactive and consult with us if there's any potential for protecting your ideas. It's probably a good idea to build your IP into your contracts, especially with employees, contractors, and partners. And perhaps most importantly, I think you need to treat your IP as part of your business growth strategy and not just use it as a legal checkbox. Because as your IP portfolio grows, your company's assets are going to grow.
Great. Madeline, can you sum it all up for us with some key takeaways?
Absolutely. The key takeaways from today's presentation include: one, intellectual property comes in many forms: patents, trademarks, copyrights, trade secrets, etc. Two, timing and proactive steps matter. Don't wait for a dispute to think about protection. Three, enforcement is about strategy, not just litigation. And four, and finally, consult with an attorney to ensure that your intellectual property is protected.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's employment law lunch and learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.